So a few months back, I made a video on Nintendo's lawsuit against Pocketpair. In that video, I said I thought that Nintendo would probably try to amend its US patent claims and add limitations to make them survive re-examination. A few weeks ago, the US Patent Office issued the next move in that proceeding. So this is a follow-up with what's going on with those Nintendo Pokémon patents in the US. I've seen a lot of reports that Nintendo's patent is getting revoked, so I wanted to walk through what is actually happening with this patent. I'll talk about what the Patent Office actually did, what it means for Nintendo, and what's worth taking from this if you're a founder thinking about your own IP. So just a quick note up front. I'm a US patent attorney, so I'll focus on what's happening at the USPTO. I haven't followed closely with what's happening on the Japan side of this case, so I'll leave that topic out of this video. So as a quick recap, back in November, the director of the US Patent Office personally ordered re-examination of one of Nintendo's US patents, the one covering summoning a sub-character to fight with the game switching between manual and automatic battle modes. In that video, I covered why the director initiated order was so unusual. The examiner working through that re-examination came back with a 104-page office action. The result was that every one of the claims in the patent got rejected, all 26 of them. The rejection was based on Section 103 for obviousness. In US patent law, if patent claims are considered obvious in light of what's already been invented, the patent examiner will reject the claims. The examiner here cited 4 earlier US patent applications. So that's the substantive update. Now let's talk about what that actually means. Because like I said, some of the reporting isn't completely accurate. Some of the headlines I've been seeing say things like, the patent was revoked. That's not actually what happened. This was a non-final rejection. The office action is basically the examiner's first written objection to the claims. It's the start of a conversation, not the end. Nintendo gets a response window. In this case, it's 2 months from when the office action was issued, but they can also extend that. During that window, they can amend the claims to narrow them, argue against the rejection, or do both. It's worth noting that a significant number of patents that face an initial non-final rejection often survive in some form. Sometimes that means that the patent owner narrows the scope of the claims and the examiner accepts their narrower version. And sometimes the patent owner makes an argument that the examiner agrees with. The important thing is that the patent doesn't disappear when a rejection comes in. It stays in force the entire time that the proceeding is open. So when a report is saying that the Nintendo patent got revoked, it isn't actually what happened. Nintendo has until the end of May to respond with extensions available. And what they file next is what determines whether the patent survives, gets narrowed, or gets rejected for good. The other piece worth understanding is what obviousness actually means in the context of patents, because this is what the whole rejection is based on. It's not that this looks like other games, so it's obvious. That's not how it works for patents. The examiner has to identify specific prior art references, usually earlier patents or publications, that would lead a person with ordinary skill in the relevant field to the claimed invention. The 4 references that the patent examiner relied on are all public US patent applications. In fact, 2 of the references are earlier work from Nintendo themselves. What's particularly interesting, and also one of the reasons this office action is so long, is that the examiner actually described 2 different obviousness combinations that both independently reach all 26 claims. This matters because Nintendo can't just overcome one combination. Even if Nintendo convinces the examiner that one combination doesn't really teach what the rejection says it does, the other combination is still standing. They have to defeat both, or at least amend their way around both. That's a meaningfully harder position to overcome. Whether either combination holds up is what Nintendo's response is going to test. They might show that the references don't actually teach what the examiner says they teach, or they might show that there's a specific reason a skilled person wouldn't have made that particular combination. Or they might amend the claims to add specific limitations. So that's where this patent goes next. But here's something else worth noting. Nintendo also filed a continuation application back on August 7, 2025. That's about a month before the original patent was issued in September. And it's about 3 months before the director ordered re-examination in November. So it looks like Nintendo actually had this hedge planned before any procedural challenge to the original patent. A continuation patent application shares the same disclosure as the original patent. It's the same invention with the same March 2023 priority date, but Nintendo can pursue different claims. So the question becomes, how different are the claims that Nintendo is pursuing in the continuation application? The continuations claim 1 adds elements that the parent patent didn't have. The biggest one is the limitation about the player character performing an action of capturing an enemy character in response to a capture instruction. That's the Pokemon catching mechanic written directly into a patent claim. The continuation also adds limitations about how the camera frames the action differently in command battles versus auto battles, and how the sub-character's visual state changes between battling and not battling. It's specifically narrower towards the catching mechanic that's most distinctive to Pokemon-style gameplay. The cited prior art generally doesn't include capture the enemy and turn it into your sub-character. That's distinctively Pokemon territory, and the continuation patent application is positioned to claim that. Based on the public records, this looks like an intentional narrowing. Nintendo's response to the parent's re-examination will tell us more, but the file itself shows the hedge appears to be targeted. Companies heavily involved in patents often file continuations before the parent patent issues. It helps keep their options open for years and to position narrower claims aimed at specific parts of the invention that are most worth protecting. One thing I want to flag, since I've seen confusion around the Japan lawsuit. The Tokyo District Court lawsuit is a separate proceeding in a separate jurisdiction over different patents, specifically Japanese patents. The patent the USPTO just rejected is a US patent, so the US decision doesn't directly affect the Tokyo case. It can be persuasive evidence in Japan, but it's not binding. Japan law decides Japanese patents. Those are two separate steps that aren't actually connected. So here's the patent strategy lesson we learned from Nintendo. Nintendo's parent patent claims tried to cover something pretty wide, basically the entire mechanic of summoning a character to fight in 1 or 2 battle modes. The wider your claims go, the more likely it is that someone else's earlier work falls inside them. And once that happens, you have an obviousness problem, which is exactly where Nintendo's patent is right now. But Nintendo also did something smart. They filed a continuation application before the parent patent issued, with narrower, more Pokemon-specific claims. Even in the worst case for the parent patent, the continuation application still gives them a second shot. So the practical takeaway is 2 parts. First, the goal isn't always the broadest possible claim language. It's the broadest defensible language. The patent that survives in 5 years is more valuable than the patent that looks great when it's granted, but collapses on the first challenge. And second, continuations are how companies keep their options open. They give you room to come back later with narrower claims aimed at what you most need protected. So what's next? Nintendo's response to the parent patent is due in a few weeks. When that response comes in, the question to watch is whether they amended the claims and how narrowly. Separately, the continuation application is pending and will eventually go through its own examination. So eventually we'll see what the examiner does with those narrower claims there. So as a quick recap, the USPTO didn't revoke anything. They issued a non-final rejection that Nintendo can respond to. The grounds were obviousness, with 2 parallel combinations the examiner proposed, which makes the rejection stronger. Nintendo also has a continuation application pending, which gives them a parallel path forward, and that continuation application is narrower towards Pokemon-specific mechanics. The Tokyo lawsuit is a separate fight under Japan law, and for founders, the lesson is broad patent claims trade short-term reach for long-term durability, and continuations are an effective hedging strategy often used by companies big into patents. I'll try to do an update when Nintendo's response comes in, or if there's movement on the continuation application. Until then, I'll see you on the next one.